This panel is the PTAB versus federal court, comparing the two forums. And we have some really important individuals on the panel. We have Warren Tuttle, former chair of United Inventors Association, and probably still a board member. He's also the head of marketblast.com, which helps inventors get licensed to companies looking for products. We have Rob Sterne here. He's the director of Kessler, Goldstein, and Fox in the Electronics Practice Group and co-chairs the firm's PTAB Trials Practice. We have Adam Mossoff, a professor of law at Antonin Scalia Law School, George Mason University. He teaches a wide range of courses, including property, patent law, trade secrets, trade law, remedies, and internet law. But Adam, you will see in hearings in Congress, often on our issue, as well as he's involved in all kinds of actions and papers and writings to help the cause. So he's a real ally. We also have Molly Metz, of course, as you guys know. And you guys, go ahead and take it. And Warren's going to be the moderator.
Great, Randy. Thank you so much. This is a real superstar panel, and it's going to be really exciting the next hour. We're going to have a lot of fun. I had a bunch of questions, but I'm going to tear them up, and we're going to start from scratch here. I think what we'll do is I'll start off with some easy questions, more overview questions, and we'll get into specifics as we go. Rob, if you don't mind, maybe I'll start with you, and we'll sort of snake back and forth to get everybody involved. But my first question to get us started, I mean, everyone knows generally what PTAB is, obviously, and we know when it came into creation. But it was billed, and I remember this very specifically, as an alternative to federal court that would be cheaper, especially for inventors, that it would be a vehicle for inventors to use, and it would be more efficient, and it would be all these wonderful things. So Rob, if we could start with you. Has that happened?
Am I on? Well, first of all, I want to say hi to all of you, and thank you very much for being here, and also to some of my more famous clients that are in the room. Yeah, it turned out to be exactly the way it was planned.
Okay, we're done here.
No, I'm here from the PTAB, and I'm here to help you. But a little bit of background. I got into this area very early on, back in 2006, when I was on the panels at the Sedona conference, and they asked me to do their very first presentation on a thing called inter-party re-exam, which was a very unused procedure, the predecessor to the IPRs, that was put into the law in 2002. And the big top litigators, they wanted to know about this procedure that nobody was using, which had come after the ex-parte re-exam process, Warren, in 1981. And so I ended up writing a paper for the Sedona Conference Journal, which by the 11th edition, which was going out in 2011, was seized by Joe Mattal and others in the Senate, and also was used extensively by 21st Century Alliance and other pro-patent groups as a document to show how maybe the system could be improved, because by this point in time, inter-party re-exams were really accelerating in terms of numbers. And I'll never forget being in a meeting with about 30 lobbyists, because you know lobbyists make a lot of money in this town, representing big tech and other groups that are trying to curtail our patent system, and members of these various groups from pharma and others, and Senate staffers. And I remember saying to them, because they were quizzing me about my paper, the Sedona paper, I said, look, you better be careful here, because the law of unintended consequences, I guarantee you, is going to rear its ugly head. And I'm very concerned about this new system. And I told them that if they did what they were going to do, they were going to make me rich. Make me rich. And you heard this gasp in the room. And frankly, many, many, many lawyers in this country have made entire careers out of their PTAB practice. 1/3 of our revenue at Sterne Kessler comes from the PTAB. And we're $150 million service revenue at Stern Kessler a year. So you have a lot of entrenched interest here to really tear the cloth away from the face. You have a lot of interest here in law firms, particularly big general practice law firms, who make a fortune with these PTAB proceedings. Okay? So let's get it up on the table. There's a lot of money here on the table. And to go back to your question, Warren, we need to do something because, as you've heard from the other speakers, the system is not fair for SMEs and individual inventors. It's just that simple. So when I was asked to be part of this conversation, because remember, I'm on both sides of the V, so I'm talking out of both sides of my mouth. So let's keep it clear. But I'm telling you, as a citizen of this country, when you see what's going on with China and others, we really need to incentivize all of you to take the risk. Remember, I started a law firm at 26, so I have some credibility on taking risk. But you have to have the ability to win. And Josh is a fantastic example of someone who has won. Molly has not won. And she's not the exception, she's the rule. So let's get into the details.
Thank you. So Adam, I'll sort of phrase the same question to you. Just as an overview, just to get us a little red meat here to get us started. But has the PTAB lived up to its marketing and billing from a number of years ago?
Thank you. And I will point out that the only academic here is the one wearing the tie. So I overdressed for the occasion. No, and in fact, I was actually, my first engagement with patent policy actually as a professor was on the Hill in 2010 and 2011, speaking to staffers and telling them that the elimination of both the first to invent, as well as in the AIA, in the American Invents Act, as well as the creation of the PTAB was going to be extremely problematic, to say the least, if not a disaster. They conceived, the classic scenario of conceiving of, oh, this agency is going to work perfectly. It's going to be staffed by experts. It's never going to make mistakes. It's never going to be captured. There's never going to be lobbying interests that are going to play a role. There's never going to be political influence that plays a role in an administrative agency, because those things have never happened. And anywhere else in the entire government, let alone in any other agency that's been created by the federal government, as distinguished from courts, which, yes, can be expensive and things of that sort, but have due process requirements and rules of evidence and follow the law. And so they were characterizing this perfectly functioning, agency. It's what economists call a nirvana fallacy. They were, and contrasting that against the real world of litigation, and saying, well, of course, then this, it's going to be efficient and quick and clean and all sorts of things of that matter. And of course, it's the exact opposite has happened. In fact, the exact opposite has happened because of those exact characterizations. Because of those characterizations and the way that they framed it, as we now well know, and from practice, from Molly and many other people, right? They didn't put in procedural safeguards. They didn't put in substantive protections for the rights of inventors and patent owners who have have had, reliable and effective property rights in their inventions in this country for over 200 years. And Congress can create, proper functioning courts outside of regular standard, what lawyers call Article III courts, your standard kind of district courts and federal appeals courts, right? The bankruptcy courts, the International Trade Commission, and many other court of federal claims, where some of you inventors may be for claims against the government. These are these are actually congressionally created courts. They're agency courts, and you wouldn't know it because they impose on them the requirements of due process and rules of evidence and things of that sort that you would expect for courts to do, and that's why they function well, and that's why everyone accepts them as legitimate functioning institutions to resolve their disputes over their rights. And that's exactly what you don't have in the PTAB. And a way that I put it to the staffers at the time, because Warren, you say exactly right, it was characterized as, this is going to be efficient, this is going to be both cheap and fast and it'll help inventors. It'll characterize as helping inventors, helping others in the innovation economy. And, and I said, one of the things that I often said to staffers at the time is, we all know the maxim, right? You can do something fast or you can do something right, but you can't do it both. And you've set up a system that is clearly designed to be fast, and that automatically tells you ahead of time that it's not going to be right. And so I don't think I don't think this was a risky bet to say that this was going to be a disaster.
So we'll get into some of those specifics, and we'll circle back as we start to pine down. But Molly, and thanks so much for doing this. You're the person up here that's actually engaged and been through it, and your heroic efforts to help others are really appreciated here. But from your personal experience, did the PTAB alternative spare you from federal court? Did it save you money? How did it work out for you?
Well, I just was making some notes, so I wrote down cheaper, faster, and alternative. We'll start with, is it an alternative? It's not. I wasn't really given a choice. My infringer presented a car part and a rope that I already cited, and the judge says, oh yeah, this looks like a bad patent. So I guess statistically, too, 74% of cases go to the PTAB. I don't really consider that an alternative. Was it cheaper? I spent over $500,000 through my IPR process. I don't know if that's cheap for you guys, but it's not for me. Faster, the whole process took 4 years. I also don't think that's very fast. That's 4 years of my life of wondering, are my patents good? Watching my infringer continually steal and sell my product. I did write down one more word, though, is what's the incentive for me to go through the PTAB? So
You get to win what you already have. Right?
So, and I asked myself, even to this day, what if I would have won at the PTAB? What did I win? I won my patents back, I guess, and I spent $500,000 on top of the $40,000 I spent in the 4 years in examination from 2008 to 2012. Did I win a ticket back to district court? Did I win a ticket for another time in IPR with my infringer? Did they get to go for that again? I think the answer is yes. So I guess that's my answer.
Well, so I'm just going to go one more back to you, Rob, and then we'll move on. But it made me think. So I had the wonderful opportunity to spend a day with Rob yesterday at Yale Law School, a superstar up there speaking to these wonderful law students. And you were explaining to them that the PTAB has gotten in the way of federal courts in that a lot of times the federal courts will stand aside while the PTAB is being adjudicated and then resume 18 months down the road. Could you talk about that a little bit more or add depth to that?
Yeah, I mean, most of the cases now, when you bring an infringement action, the defendant files an IPR, usually it's an IPR, and then immediately when the IPR is instituted, which occurs 6 months after filing, and there's a high percentage that do get instituted, which means that they're going to go forward with the so-called trial, the administrative process. Once that happens, the standard playbook of the attorneys on the defendant's side, of course, is to file a motion for stay. And they argue to the judge, they say, Your Honor, why should you, as a very busy Article III judge, continue on with this case until the PTAB has done its job? They're the expert government agency. And then, of course, the Federal Circuit reviews their job. And if the patent gets cleared and gets gold-plated, then we'll be back. And if not, you won't have wasted any of the court's time and your time with this case. And so most cases get stayed. And the problem with this is, remember, it was supposed to be faster, cheaper, and better. So faster means you've added 4 years to the process in many cases. For example, if the district court was going to take normally 3 to 4 years, you now add this 3 to 4 years of the IPR. So now you're up to 6 to 8 years. And the problem is that most small inventors, small and medium-sized enterprises have no ability to deal with an 8 to 10 year case. And what this really comes down to, because I've been studying the new Unified Patent Court in Europe extensively, is money and time. We have to have a system that's fast, that really is fast, and it really has to be cheaper, and it really has to be better. And I don't think we've got that. And I can give you all details on this, that, and the other, but what scares me is it's putting an incredible damper on investment, because I represent many startups and many medium-sized companies. It's putting a real damper on investment in R&D in this country, because if you tell the management and their board that you really don't have any certainty as to your ability to legally protect this investment, they're going to say, well, why should we do it?
Right. IP being the collateral and the property right that everything is based upon. So, Adam, if I could shift gears, because we could probably stay on that topic for a few more hours, which is fascinating. But let's start getting into some of the specifics. So I want to talk about validity. And I was sitting right here, I think, with Randy Landau and a few of the US men a few years ago, and we were having a conference, and I didn't quite understand, I'm not an attorney, I didn't understand some of the details. But
that's a virtue.
yeah, somebody said me, now you're bragging.
Yeah.
But at federal court, if you have an issued patent, you're at least presumed valid, which is presumed valid.
Yes.
The person who's on the other side has to at least clear that hurdle. But at PTAB, that validity was removed once they agree to see it. Number one, why is that? And number two, why is that? Talk about that.
Sure. So yes, as I often tell my students, only half jokingly, since they're law students, that they're in the process of going to the dark side. And Luke was wrong. There would be no good left in them when they're done as lawyers. Set some context. So the United States, first of all, I just want to frame this because this is often stated, but it is true that we were actually the first country that took the position that patents were property rights. So in England, they were viewed as personal monopoly privileges granted by the Crown. This is how they were viewed in many other countries at the time. We were the very first country that took the position very seriously that no, these are property rights. They're to be treated like property rights, like any other property right. They can be transferred, licensed. You can, in fact, the very first patent that was issued was licensed. They didn't manufacture. And as a result of this, right, that the courts applied to patents very early on various legal presumptions that favored title owners and other types of property, land, and personal goods. The presumptions that favored them if there was an ambiguity or a question about the document. It was called what we call in the law canons of construction for how you interpret the legal documents, because as we all know, there's disputes over land and title deeds and wills all the time, and the position taken very early on in this country, and this is because this is what I do as an academic. I spend my time, reading the history. That's why Senator Kuhn said I need to get out more often. That they very early on said this is just like any other title deed document, and we're going to apply the exact same rules for interpreting them. So we're going to liberally construe them in favor of the patent owner, in the same way that we construe title documents in favor of property owners, your real estate deeds or other types of documents. Then when we adopted the examination system, the idea that they're also examined came and reinforced that, and this is what led to what we now call the presumption of validity, that you have, this goes through the examination process and it's a property right, we protect it, we presume it to be valid. And so that puts a thumb on the scale, so to speak, in favor of the property owner, the patent owner, when there's a dispute about the validity of the patent, when it's challenged in some way, shape, or form as being invalid. Now, you can challenge title deeds as being invalid. You don't use the proper legal terminology. There's other defects in the title deed, and you have similar types of challenges to patents given what we call the patentability requirements. A patent has to be new, it has to be useful, and things of this sort. And so these arguments could be made in court. But you had to overcome this presumption of validity, which means, as many of you know, you have a very high requirement of evidence, because I know it's a shock to hear this, but courts follow rules of evidence. And so therefore, what we call clear and convincing in the law, which is the clear and convincing evidentiary standard, we call that in the law, which is the highest evidentiary hurdle that you have to overcome to prove that a patent is invalid. It's very hard to overcome that. And also the legal presumptions as well in favor of the submissions of the materials that are trying to invalidate it. All right, so that's what exists in the court. And of course, when I mentioned...
So in other words, having a patent has meaning.
Has meaning, and this is what makes it a reliable and effective property right that serves as the basis for venture capital investment, licensing, manufacturing, and all the activities that innovators have been engaging in, from Samuel Colt with his repeating firearm, to Charles Goodyear with his rubber, to Samuel Morse with his telegraph, to Charles Goodyear with, as I mentioned, with his rubber, Thomas Edison, Nikola Tesla, and all of you inventors and innovators here in this room. So this is, ideally at least what you should do and what they did historically. So when I mentioned, they imagined the PTAB would function perfectly, so they're like, we don't need to impose any restrictions or requirements on it in the law, in the American Invents Act. We don't need to impose procedural guardrails and substantive protections. They will know what to do at the USPTO, and they won't be affected by false narratives. I don't know, like patent troll, for instance. They won't be affected by, lobbying efforts, from companies, multi-million-dollar companies that have interest in invalidating patents or stealing technologies. They'll impose the same types of requirements that that we would expect judges to impose and things of this sort. And so they weren't told what standard to adopt at the PTAB. And the position at the USPTO under Director Michelle Lee was, this is a renewal, this is a second look. We are essentially examining again the patent. This is why they do the do-over, which they're actually not supposed to do that as well, looking at the exact same evidence that was looked at in the initial examination. By the way, this was exactly what was said was not happen, that the PTAB was not supposed to be a do-over of the examination. There was never the purpose of this. Ron knows this really well as well. And so they said, well, in examination, you don't get clear and convincing. You don't get the presumption of validity because it's not an issued patent yet. So we're not going to provide that same standard of review. And this is why you have the lesson, it's much easier to invalidate. It's one of the contributing factors for why you have, I think, 82% or 85% invalidation rate now at the PTAB. At one point in the covered business method program, it was 100%. There was 100% of the patents that they reviewed in the covered business method were found to be invalid. I mean, if that's not an institution that's out of whack.
Have you, before I go into Molly to humanize, but have you ever heard of a football game where the game ended and then later in the locker room they decided to go out and replay the last quarter?
Yeah.
Okay. No. I guess the answer is no.
Yeah. Geek, I don't watch sports.
Well, you get this. So Molly, I want to ask you the same question and humanize it because you went through an arduous process of getting your patent approved, and it was approved, and you did everything by the rules, and you had a patent attorney representing you, and you played by what we consider a fair playing field in American, and then obviously the shock that must have happened when suddenly this game that you were playing, sort of the football metaphor, was pulled away from you like Charlie Brown. And just tell me humanly, how that felt, the validity issue, and how you responded to that at PTAB.
Yeah, so I think your original question, can you state the question again?
It was, what the heck was going on there? How, in a human terms, if what your experience was, to talk about the validity.
So to be
issue.
presented with, we have to check the validity of your patent. What did that do for me? Well, I kind of talked about this a little bit earlier, but you spend 4 years in examination, you spend the $40,000, that's one thing, but I had over 150 infringers. I changed the entire, sport of fitness with my technology. I think I have a pretty big invention when it comes to what inventions are. So that's confusing when you start your business, you invest in your business, and you base it on that, and you have this property right that says you can protect it's really confusing for me because I have all my marketing materials and my website that says patented. We're required to do that. And then I took money from companies on a valid patent for years. And so when I lost my patents, I remember telling Dirk, I said, we're going to get sued by all these companies. We took money. I have been going around the world falsely showing that I had a patent. I mean, I really believe that. I still believe that today. And so when I present that question, when I ask, members of Congress or, employees of the USPTO, they said, no, you did have a valid patent. Okay, well then what about Rogue Fitness? Why are they exempt? They stole from 2012 to 2021. Why are they exempt? So I'm just talking out loud. These are just confusing issues for an inventor. You're told you have a valid patent, and then you're told not. I think I wanted to say one more thing with that. I think maybe two, is why wasn't my examiner allowed in the room during my IPR? Why did I have to get an expert? I'm the expert, I thought. I don't get to speak in the IPR either. My examiner knows exactly why I got my patent and what it meant, and it's very confusing as to why aren't they involved? I don't even know if anyone has that answer. Maybe you guys have that answer as to why they're not.
That was absolutely going to be my next question. Yeah, the examiner, no, because from what I understand, an expert witness, and this is from the PTO, has told me themselves, it has an average cost of about $125,000 to bring in someone from the outside. Yeah. So did you ask for the examiner to be brought in, and or just how did that work?
When you're going through that, I mean, that was my first time, and I probably my only time doing that. You're just there was a question earlier for Josh about opening your mouth and talking to your attorneys and asking questions. I don't know if I asked for that. I think I just trusted the process. Dirk, did we ask that? No.
Well, I don't think even if you had asked, I don't think it was available.
Yeah. So can I say one more thing to that?
Yeah, absolutely.
I just have a friend in Colorado. I just wanted to say this out loud. I think it's very strange. She has a patent. She has 17 patents. Of which one is in the 20th year. I just wanted to say it's very interesting that she's being IPR'd in her 20th year. The company that's IPRing her, it's a tongue twister, has spent $20 million to invalidate her patents. Why are her patents bad in the 20th year, and why is that company spending $20 million to do it? What does that tell us? Okay.
Yeah. Interesting.
Yes,
Well,
I just wanted to say that out loud. I find that interesting.
Good question. And Rob, could you dive in a little bit more on the role of the examiner in the PTAB process and why they're not included, and from your experience, expert witnesses, what it actually costs and all that good stuff?
Well, when we were dealing with writing the law, we wondered how they were going to implement the law. And unfortunately for many of us, and I'm not just talking for this group, but even some very large companies, the way the law was actually implemented was nothing like what was proposed or should have been done. But the rules are the rules are the rules. And the PTAB judges enforce those rules vigorously. And if you try to get outside of those rules, you pay a price. So you follow the rules. The way the rules are, the examiner is never allowed to comment or testify. At the beginning, you couldn't even rely on what the examiner had done. And as our professor told us, you could essentially do a do-over with the same art. So they have, under Andrei Iancu's regime, they've narrowed that. So you have, as a challenger, you have to be able to explain in writing exactly what the examiner did wrong or what she did not perceive or should have perceived, or et cetera, concerning the original art, patents and printed publications, remember, that was in the original examination. Now, when it comes to new stuff, all bets are off because the presumption basically is gone about the examination. Experts play an unbelievably powerful and important role in these processes. Both sides need an expert. I have an expert that says that the cover of the book is yellow. And Adam, the infringer, says, no, my expert says the color of the book is orange. Yellow, orange. You know, that could be very tricky. And so these experts get usually paid between $20,000 and $150,000 during the course of a IPR for putting together expert reports, having their deposition taken, which is not the same as a deposition in the district courts or the ITC, but more along the lines of quizzing them about their report, their expert report. And it's the expert report and the patents and the printed publications that form the evidentiary basis on which the three administrative patent judge panel makes their decision about invalidity. It's that creates the evidentiary record. There is no live testimony in the final hearing, which is only between 30 minutes and maybe an hour and a half per side. So it's not like a district court trial. And of course, in a district court, you have many more issues than just this. So the time to address validity in the district court may not be much longer. But there is no cross-examination by the panel of judges in the PTAB for credibility. So you can basically find an expert, and I know this comes as a surprise to you all, but you might be able to find an expert to say whatever you want that expert to say. You know, when I get back to the firm, I'm sure the managing partner will be sitting in my office saying, Rob, we warned you.
See, this is why I love Rob. Okay.
So here's the way it works. There are bad patents out there. Let's be honest. Let's admit it. There are patents out there that should not have been granted. But the point is, if you do everything you can possibly do, you do searches, you write the best patent specification, you get the best attorneys, you put the best evidence forward, isn't it fair for your investors and for your employees and for your management to be able to say, well, you know, there's a high presumption that our patent is valid. And the problem is with the PTAB, that's going away. So I do want you to think that there are bad patents out there, but we do have to have a system in my world where if you check all the boxes, you ought to have something worth checking all the boxes.
Well, great answer. Hey, Adam, I'm going to switch gears, but if you want to weigh in on that subject at all of the expert witness, feel welcome to, and then I'm going to ask you a follow-up.
Oh, okay. Yeah, so Rob has beautifully and I think very elegantly kind of made real what it means when I said, you know, courts follow rules of evidence and due process, and you don't have that with the PTAB. And it's funny how you were like, well, the rules are the rules. Well, it seems at the PTAB that the rules are the rules until they don't want them to be the rules, and then they change them. Which, by the way, is the whole point of why agencies are created. Administrative agencies that were created precisely to be more flexible and to be more policy-oriented. And they were kind of trying to have their cake and eat it too at the PTAB. They wanted something to say, well, we're going to follow these legal requirements for what makes a patent valid, but we want it to be flexible and nimble like an agency. Well, you can't do that. You square that circle. It's got to be one or the other. And at the end of the day, as the Supreme Court confirmed in one of the, I think, 7 cases that is now decided out of the PTAB in the past 10 years, you will be hard-pressed to find any agency that's produced that many Supreme Court decisions in such a short period of time. That it is primarily an agency. So, for instance, so they stack panels when a decision is not reached. They will consider evidence that they're supposed to not consider under their own rules. They will, and they'll do other things as well. That they'll permit serial petitions with.
Is there an incentive to do this, or this is just sort of things that happen by happenstance?
Well, I mean, so it's. That's an interesting question. Now. My perspective on it is that the institution as set up, they were given a mission, cancel patents. There are some, and there's always going to be some invalid patents. I don't like the term bad patents because it makes it sound like it's a patent from the wrong side of the tracks. It's smoking. Rides a motorcycle, Warren. So we're motorcyclists.
Bad.
So, but yeah. So you know. The USPTO, it's staffed by humans. You know, humans make mistakes. You're never going to have 100% valid patents, just like you're never going to have 100% correct anything in any human-run institution. And so, and by the way, it was never established that we actually have more invalid patents now than we have had in the past, or that the courts actually were not doing an effective job at this. There's zero, and I will emphasize this, empirical study, statistical study that has shown that today, as opposed to yesteryear, times before, there were more invalid patents. That there is no study that does that. So there are going to be some invalid patents, but they created this institution, I think, as Molly has described it, right? It's a kind of a heads I win, tails you lose situation. Its job is to cancel patents, and that's all its job is to do. And so you had mission capture, and you had mission capture being driven by an agency that was very much informed, I think, at the time by the patent troll narrative that was being pushed by hundreds of millions of dollars, as Rob emphasized, by large companies that had an interest in undermining the patent system to engage in a well-established business practice of predatory infringement. And I have a new white paper on this that just published this past June called, Big Tech's Abuse of Patent Owners at the PTAB Must End. Because the top 10 petitioners at the PTAB are all big tech companies, with one exception, Unified Patents, which is just a PTAB filing agency firm that just files on behalf of big tech. So, so this is.
Well, I want to come back to that. That'll be sort of my final question to come back a little bit more in depth. But before we get to you, Molly, let's just switch subjects just a little bit to talk about another specific. Tell me, Adam, about unlimited bites at the apple. And what goes on in court and what happens under the PTAB as far as you get through one petition and maybe it could start back up again. But could you speak to that a little bit?
Rob or me? Me again?
Yeah, well, actually, you know what? Let's go to Rob, and then I'm going to come down to you, and then we'll do this too. Yeah.
He knows this very well.
Oh, yeah, Rob. Okay, yeah.
So I am sitting at a Sedona conference next to a federal judge, Article III judge from Northern California. And we're talking about the this thing. Remember, I told you this inter-party re-exam, the predecessor to IPRs, and on her pad is second bite at the apple, circled in red. So I sit down and I explained that while the court may find the patent valid, remember, no stay here, they're both running in parallel, which happens in Texas, for example. The district court finds the patent valid. On the same art, the PTO finds the patent later to be invalid. And therefore, what happens is that supersedes, I'm not going to use the word trump, that supersedes the first decision, the valid finding of validity in the district court. And so I said, the defense bar, when I explained this to them, they said, oh, wow, we get a second bite at the apple. In other words, we can lose the case in the district court on validity as a defendant, but we can then reverse that at the time it was called the Board of Patent Appeals and Interferences, or actually the Central Re-Exam Unit. And she was so mad at me. She said, you have offended me. And I said, Your Honor, what have I done wrong this time? And she said, you're going to let me do all this work and then you're going to run to the patent office and undo everything I've done? I mean, like, really? I said, Your Honor, don't shoot me. This is the way the system is working. So the point is, it's never over, it's never over, it's never over for the patent owner. We could make a song. And the idea is that yes, a particular defendant may not be able to bring another attack, but other defendants, other parties, other businesses whose sole model is to sell protection insurance to a group of large companies, but then stand back and say, we make all the decisions on attacking the patents that are being asserted against you. This is what's developed. You have this whole system where you win in the first IPR, it ain't over. You win in the second IPR, it ain't over. So it's often described as death by 1,000 cuts, because when you lose, the patent owner has to win every single time. The accused infringers only have to win once.
And then again, we go back to what Molly said. What do you win? You win what you already had. So there's nothing at the end of the day.
And I want to just make two kind of final points on what Rob just described. One is, I want to emphasize this, is that the PTAB was promised not to be a parallel proceeding. It originally was characterized as this was what would occur when the mom and pop gets the demand letter from the invalid patent. They would quickly and efficiently get the patent invalidated before there was even a lawsuit filed. It was not intended to be a parallel proceeding to run concurrently with a district court proceeding. They never thought of that this was going to be the situation that was going to arise, because that's what leads to strategic abuse and the use of it as a method of imposing costs on patent owners as a key for predatory infringement. And I want to reemphasize, this is not second bite at the apple. It's not even a third bite at the apple. We're talking 20, 25, 30 bites at the apple.
It's that one when you get down to the seeds?
Yeah, I mean, the apple's long gone, exactly. And this is what, you've probably heard the term serial petitioning. I don't like that phrase because it makes it sound like it's cornflakes or Frosted Flakes or something, which is kind of nice. I mean, no, this is multiple submissions to invalidate a patent, again and again and again. And in fact, it's very interesting. One empirical study was done by a patent law professor at the University of Illinois about 4 or 5 years ago, where he looked at the multiple submissions where petitioners were simply adding in or taking out just one argument to make it a different petition, but it was 90% same petition. And guess what he found? The chances of the grant of the same petition, which was essentially the exact same petition, the chances of the grant of an actual hearing went up, even though it was essentially the same petition.
Wow. Well, let me piggyback on that, because we've got a couple more questions. I'm looking forward, Molly, to asking you something. But could you just add to that that you don't have to be, how do I want to say this, litigant, or you don't have to be part of the case in order to bring this forward in PTAB? Is that different than court? Could you just talk about that?
Yeah, so this is what we call in the law a standing requirement. So normally if you go to court, it's because someone has infringed your rights, and so you are taking them to court saying they've harmed me, and that's what gives you, quote, what we call in the law standing, which means I've actually been threatened. My rights are actually being threatened. This is why I need to get an injunction. Or I've actually been damaged already, like the people who had already committed infringement, and therefore I get damages for the past infringement that's already happened and an injunction to stop it going forward. And this was one of the features of the PTAB, where they said it'll work perfectly. Don't worry. In 2011, we're handing it over to the experts at the USPTO. Everything's going to work just fine. Is that they said, so they had imposed no standing requirement. So anyone in the world, someone in Kazakhstan can file a PTAB petition to invalidate a U.S. patent. And they don't need a reason. They don't need to be threatened with a lawsuit. And by the way, this is exactly why PTAB filing firms like Unified Patents came into existence.
Do they have an office in Kazakhstan?
So,
all right. Well, let's. Molly, I'm going to ask you one, and then I'm going to end up with the big final statement. But Molly, could you just talk for a moment about your experience with? So you have these. Are they actually called judges? I guess they're called judges, right? But they don't necessarily have a law degree, and they don't necessarily have been approved, like Judge Braden here would have been approved. They haven't had to go through an approval process. What was your experience like with that, as far as their expertise on the subject and the fact that they were judges but not real judges? Can you talk to that?
Okay, so it's a difficult thing to answer, because I think I told you guys our oral argument was over a Zoom call, so my impression of one of the judges was that they didn't care because they had a dog, and it just didn't seem like a big deal. I can say, based on their final written decision, there was nowhere in their decisions that they sided with our expert. They always sided with our infringer's expert. And I asked the question, where is their reasoning? You know, do they have thoughts of their own? And the answer is no. They just side with the other, with your infringer's expert. So my thoughts on those judges are, they don't care. Maybe this expert of my infringer has sold them on this idea that my patents are invalid, or maybe they were sold in the beginning when the IPR was accepted, because those same 3 judges that take your IPR are the same 3 judges that decide on your fate. So from the very get-go, they've got a lot of hindsight bias. And I even remember reading our first paper. I'm not very good with all the legal words with this, but you know, it said something like, I wish Dirk was up here because he knows what I want to say, but it basically said, your patent is most likely invalid, so we're going to accept the IPR. So that's very confusing to read that because you're already doomed from the get-go. Yeah. So I hope I'm answering that question. I don't know my judges, I didn't get to see them, but there was no information as to why they chose to invalidate my patent, other than they sided with my expert. I'm sorry, with my infringer's expert.
Brings up a really interesting issue about the selection of these and then who adjudicates. But we'll just come to the final question here, and then we'll start with Rob and move down the aisle, and then I think Randy may want to open up to some questions. And this is an interesting question. So this sort of pulls the whole thing together. Like, where did this come from? You know, what's sort of the deeper dive that we've done on this? But since the PTAB is a self-funding system, in other words, it's paid for by the people that bring these suits to you know, in front of the USPTO, in front of PTAB, and they pay a significant amount of money to do that. And it's not the inventors that are leading this, it's the bigger companies. And these companies typically, as Rob has described earlier, have been sued for infringement or whatever, and then they go the PTAB route to sort of clear the docket. You have a process here where mechanically the PTAB is funded and by the people who are really the infringers. And Rob, if you would just speak to that, I mean, isn't that a tremendous bias there right to start with as far as fairness on this? Does that question make sense, I hope?
Oh, yeah. I mean, it's a question that's asked in every client counseling meeting I have, every single one. I mean, it's speculation. You would hope that these judges are trying to do everything that they possibly can. These are smart people. These are good people. They are well-educated. They are carefully selected. Yes, I don't mean to cast any aspersion on any of these judges because I've got to be before you, and I want you to know that I believe in you. But the problem is it's not the judges as much, in my opinion, as the system. The system is going to have metrics that essentially evaluate the performance of the judge. And I'm no expert on this. I know others in this room are, but in order to have a high performance review, not only do you have to do quality work, but you have to do a certain amount of work. And if you don't have enough work to do, you got a problem. And therefore, what are you going to want to do? You're going to want to make sure that you have a full docket. So the cynics will tell you that they will deliberately tune the amount of work they have, and that so that they don't have too little or too much. And that is, the cynics will tell you that that has bearing on what they institute and what they don't institute.
Adam?
Yeah, so it's an interesting question. Does funding actually, create bad incentives? I kind of superficially, if you say someone's funded to do something, right? That it creates I think superficially a question of whether there's bad incentives or not. But so the way I think of it is, well, let's say it was completely funded by just the government, generally, not funded by the petitioners. would you still have all the same problems? And I think you would, because you have an agency that was created, a tribunal, an administrative tribunal was created without any procedural safeguards, that has incentives to have multiple petitions filed by people committing predatory infringement. You have all of the other structural problems with the institution. So I don't think it's reducible really down to the fact that they're paid for money. And in fact, during the debates over whether we should create the PTAB, one of the common arguments was, well, you have bad incentives on the other side of the USPTO because examiners have fees paid by the applicants. And so the argument was they're incentivized to issue all these patents. The argument was we're awash in bad patents because examiners are incentivized to grant patents.
You used the B word.
I know, because you already opened the door, and I'm quoting them. So the argument was we're washing bad patents, I prefer actually to stick to the evidence and the nature of the actual structure of the institution and the rules, and to show that, even if regardless of whether someone's being paid or what they're being paid, would you still end up in a similar situation? And I think you would, for the same reason that, Congress keeps passing bad laws on patents, and they're not paid by they're paid by lobbyists, right? But they're affected by the narrative, the more broad narrative that is created, such as the patent troll narrative and things of that sort.
Wait, can I say something? Yes, I'm sorry. That's okay. I just want to challenge what you just said. I'm the jock challenging the, what'd you call yourself earlier? Yeah, okay, the motorcycle rider.
I always tell my students, first you have to say wrong, Professor Mossoff.
You're wrong.
Thank you.
This was the topic of incentives, and you gave the example of, we're incentivizing the examiners, right? We're giving them money to give us.
Well, that was the argument. I'm not.
No,
yeah, okay.
Okay, it's an argument, and so then you take that argument a little bit step further, and it's my understanding that when my infringer IPRs me, if they don't prevail, they get their money back. So I didn't prevail. My patent was taken away. Why don't I get my money back?
Mm-hmm. Yeah. Well, that would be incentive for continually filing petitions, especially if they're rejected. Yes, mm-hmm. but then you could still say, well, but they could set up the rules such that it would be harder to actually institute, and they could set up the rules such that they required evidence, proper evidence, and due process. Mm-hmm. So even if you had the bad incentive to file, if you had a properly structured institution, right, then you could still potentially have a properly run processes where you wouldn't have your rights abused.
So next year we'll talk about who wrote these rules anyway. But anyway.
All right.
Can I just say one more thing, or we have time?
Well, Rob.
It just spurred me to think of this topic. We were traveling around through Congress yesterday, and I had a great group and a woman with me who I just met this weekend, and she's wonderful. I just wanted to say this out loud: is why don't we have a process in place for serial IPRs, in the sense where if there's a company out there who has IPR'd other companies, more than 6 times, shouldn't they be put on a list? Aren't they abusing the system? Why aren't they being recognized when they're going through these IPRs as being a serial user of the system? I think it's wrong that we don't. You can go out in this world and you can, I'm going to use like an example, but I don't know what example to use, but we have laws in place for people who do abusive things. If they do it once, okay, they get a slap on the wrist. Maybe they do it twice, and then they go to jail. So we put so much focus on changing the system, and it's very good, but there are people abusing the system, and I think they should be, put on a list.
All right. Thank you, Molly. And there should be criminal penalties for patent infringement.
What's that?
There should be criminal penalties for patent infringement.
Yes.
Anyway, so guys, we've gone a little over time, but we're going to have a few questions. You guys have to be very efficient, okay? We'll start with Eric. Go ahead. Okay, good.
Is this on? Okay. I'm going to first state, I'm going to agree with Cornell law, sorry. The federal district courts have original jurisdiction over all civil cases arising under any federal law relating to patents, right? So why didn't Molly get her trial when the Amendment 7 of the U.S. Constitution was ratified on December 15, 1791, It protects the right of citizens to have a jury trial in federal courts with civil cases where the claim exceeds a certain dollar amount. And then one little second question in there, Molly, who owns your patent now and why haven't you filed in PTAB against them?
Who owns my patent now?
Yes, who?
Oh,
My patent is in my backpack in the back
No, no,
corner.
no, no.
Oh,
The patent that was taken away from you, who now owns the rights to
it's
that patent?
canceled. It's non-existent.
So there's no patent able
right.
to be used?
It's gone.
Right.
It's invalidated. It's nothing.
Anyone can use it.
So now
or
anybody
the
can make their
technology.
jump rope?
Yes.
Okay, but let me ask you, why is she being denied an amendment to the Constitution?
The short answer is because the Supreme Court said that she's not. This was actually one of the cases. I mentioned there were 7 cases that have been coming out of the PTAB. One of the cases was actually a Seventh Amendment jury trial challenge under the Constitution to the PTAB. It's called Oil States versus Greens Energy, and in that case, the Supreme Court said that that the Seventh Amendment doesn't apply because they said that this is effectively a this is the do-over argument.
So double jeopardy.
No, it's not a double jeopardy issue. Double jeopardy only applies also in criminal context.
Okay.
They effectively said, since they're reviewing the patentability requirements, this is like when you're applying for the patent in the first place. And therefore, it is, at that point, it's not a property right. It hasn't been issued. You don't have a title instrument in it. So it's more of like a privilege or a special grant at that point.
government franchise.
Yes. And so in those contexts, the government has the full authority to take away franchises and special grants. So, when it creates a monopoly or a grant, to a utility company, it can control the terms under which they can use it and things of that sort without various constitutional restrictions that are imposed on it. And so the Supreme Court said that. Now, I disagree with that, and I filed a brief, an amicus brief, it's called Friend of the Court brief in that case, with a bunch of other scholars saying, you should actually find that that patents are property rights and that this is a violation of the Constitution. But the Supreme Court disagreed.
And I'm
So-
sorry for
So
throwing
don't
one
expect the
last...
Supreme Court to help us. This is why we have to get legislation.
Absolutely. And I'm sorry for throwing one more question in there that
Please hurry.
for people like Molly, who has a physical product, not something that is digital, would it have helped her if she had had a copyright about everything that she had done with it previous to the fact that she was brought to the PTAB? Because that is enforceable.
It's just very quickly, just a couple sentences. It's very interesting. People who have copyrights, especially in digital content, have very similar problems with both the Supreme Court, which has diminished their rights significantly in a lot of contexts, and with massive predatory infringement. So there has been strategic litigation and strategic lobbying that has resulted in a significant restriction of copyright owners' rights, particularly under a doctrine in copyright law called fair use. And a lot of it motivated by the exact same companies that we talk about as being sources of predatory infringement in the patent context, like Google.
But the copyright, though, does not cover your actual physical invention. It might cover your manuals and things if they copied them.
You can copyright software code.
Okay, but we're talking about physical inventions like Molly's.
Yeah, but that's why he said a digital context.
Yeah. Anyway.
Yeah.
All right, next, Eric. Again, be very efficient. We don't have much time here.
I'm sure our learned panel participants, at least those with a legal background and education, would recognize that one of the strongest factors in the development of civil procedure over the last couple of centuries has been to avoid prejudice to parties in process or at trial. What happened to judicial discretion so as to elevate judicial economy so far over prejudice to parties at court? Specifically, this isn't about administrative procedure here, right, Professor? Why, when considering stays in favor of a PTAB proceeding, is prejudice to the inventor or patent holder of years lost off their patent term, even if eventually victorious, not respected and similarly upheld? Thank you.
You deal with these issues. You should take that.
Well, I mean, you're saying that, you know, the, 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 if you win the PTAB proceeding, you should get 3 years more on your patent.
I'm saying, why do judges say this argument of judicial economy is so immediately compelling that I'm not even going to think about prejudice to the other party?
Well, the judges control their docket, and they're not under a timeline. The PTAB is under a timeline, a statutory timeline. They have to review the filing and make an institution decision in the first 6 months, and then there's a 12-month period that they have to conduct the PTAB trial. And that's in the statute because before, they could take for years. So that was the attempt to try to expedite the PTAB process to make it very timely. But the point is, when it comes to the district courts, the judges control their docket, and they don't have specific timelines that they have to comply with. And so your point, if I understand correctly, your point is if you win at the PTAB, why shouldn't you get some years back on your 20-year term? But that has never gotten much traction.
But I'm thinking that the judges are entirely ignoring prejudice to one of the parties in favor of the other party in the proceeding and their own notions of judicial economy. That's a judge's decision. That's not an administrative decision. Whether to stay or not while PTAB might be necessary.
Well, I mean, there are judges that would agree with you that there's absolutely no reason to stay these proceedings, but most judges don't want to deal with patent cases, is the cynical view. And the other point is they're overloaded with criminal cases, so there's no requirement that the judge can't stay. And frankly, the Federal Circuit has gone after some judges in some decisions that have refused to stay. So your point is good, but the point is, in order to get around the Seventh Amendment problem, they kept this parallel system. That's how they got around the Seventh Amendment problem.
All right. Harold, and then Paul, and be very efficient, then we got to go to lunch.
This is kind of a wild idea, but I'm thinking we could possibly turn this around against the corporations. Anybody in here could file a charge against the big corporations. We'll have to pay, I think, $40,000 to charge them, but when we fail, and we'll get that money back and we can do it again. We could possibly flood the system. Is that not feasible?
As a practical matter, no, because for them, the tens of thousands or even hundreds of thousands that they have to spend in defending an IPR is a drop in the ocean. You know how much cash, and I mean cash, in the bank Apple has? 200. I mean,
They're bigger than most countries.
$250 billion cash in the bank. Their in-house legal department has a budget. You ready for this, Rob? $1 billion.
You mean 1 million. You mean 1 million.
No, billion with a B. I mean, and so it's yeah. I mean, there's no number of petitions that you could file against these companies where they would say, yeah, this is an issue. In fact, this is exactly the predatory infringement practice, right? Because they know they have to spend some money on their lawyers, even in defending and filing petitions, but then in the end they still win because they make more money from stealing the technology.
Yeah, it wouldn't cost us anything because we get our money back when we lose.
I think you ought to do it.
I heard Sterne and Kessler is going to do that pro
We need to
bono.
move along. Paul, you're going to be last because I know you have a final statement.
Yeah, we'll file 500 by tomorrow.
Jackie, go ahead, but Jackie, we really are out of time, so go
Oh.
quick. Thanks. No, go ahead. No, go ahead.
One of the things, hi, I'm Jackie. I reinvented the shower cap. You'll hear my story tomorrow. It's good, and then it got bad. One of the things that has been very present for me is my lawyers are literally all over what I can say and not say this weekend. And I think we've had a lot of conversations about that. But one of the most empowering things about this was how good it felt to share the story yesterday. And I'm curious what your thoughts are on the biggest threat to us as inventors, especially independent ones, is the inability to use our platform and the muzzle, right? What are your thoughts on defamation or any work in protection for inventors to be able to use their voice when they're going through this multi-year process?
Well, any filing that your attorneys make is protected, right? But the problem is that you want to speak out, right?
Yes.
Yeah. So I get it. And I've had this conversation many times. And it's not fair. It's not fair. It's intimidation. I mean, there are partners in my law firm who, if they were in the room, they'd be ready to kill me when I walk out the door. So the point is, you're a reasonable person. And so my advice is just tell your story without any fanfare, just the facts.
Well,
All right, Paul, go ahead.
So the PTAB was created because judges are not equipped and juries aren't smart enough to figure out technology. So I have two questions. One's for Molly, and I'll give you both questions. The other's for Adam and what was your name with the funny hair? So I understand that a court can get a special master and they can select that person based on the technology that they're looking at. That special master works for the judge and is paid for by the parties. So they can get the expertise they need. And I need to confirm that with you, and if you got some comments on that. But Molly, who were your judges and what was their experience? Did they have any experience in your particular jump rope technology?
I don't remember my judges' names. I don't memorize that. But they had no experience in my technology. Aeronautical engineer, chemistry, and bio something.
And I guess
Biochemistry.
70% of the judges have zero experience in their undergrad. So is the PTAB actually fixing the problem of juries just not being smart enough to figure out technology?
Are you asking me that?
I'm asking the panel.
Well, I can tell you that my panel of judges decided with my infringer based on it's called 103 obviousness. Attorneys know what that means, but my infringers had to follow the guidance of showing my patents were invalid under 103, and they had to show prior art, and then there had to be a reason to combine the art. And in the case where they said, hey, Molly had a reason to combine these two because she fixed a problem with these prior arts of winding in a jump rope. Nowhere in their docket of information was there a problem with this jump rope with winding. So when that was asked about, the judges asked my infringer's attorney and said, where would I find this? And he fumbled his papers like this, and he said, well, you know, when you jump rope like this, which I don't know what that is, but you can also jump rope
What an
like this.
uncoordinated
You can also
nerd.
jump rope like this. And so the basis of me solving a problem was based on their attorneys waving their hands up and down, showing that that's what would have made a rope wind upon itself. So where am I going with this? I'm just answering your question, I guess, is those were my judges, and that's how they took that information and decided that my patents were invalid.
The answer is that your judges were not experts like the PTAB is supposed to be, and you could have gotten an expert brought into a court who actually knows jump ropes.
Yes, and everyone in here, if you were on my jury, we would understand that that was not right.
So I want to thank you guys. This has been a great panel. Thank you. Rob, I hope you don't get fired.
I'll try my best.
And by everyone, hold your seats for a minute. I'm going to make an announcement before we go to lunch, but thank you guys.
Hey, can I just add one more thing? So this panel was sponsored by the United States Intellectual Property Alliance, which you'll see a sign over here. It's a fairly new organization that has about 100 board members, so it's quite large, which represents a large part of the IP community. and Scott Frank, who's happens to be in charge of intellectual property for AT&T. Was his brainchild, but I have to say he's been incredibly receptive to the plights of inventors and allowing us to do these things. So they also help fund lunch, and just good people, and that's where I met Adam and Rob, and meeting new people. And for me, it's a way to get the inventor message in front of influential people, an organization, which is why I joined. So thank you to the USIPA for sponsoring this.
All right.
Thanks.
And thank you, Warren. So I want to say a couple things. This probably should have been said earlier. Nothing you hear at this conference should be considered legal advice, even if it's coming from a very high-level attorney. It's not legal advice. Get with your attorneys, or maybe get with them specifically to get legal advice. Another thing is, just to make it very clear, we don't have any problem at all with the examiners. We like the examiners. We think the patent examiners are doing a great job. It's the PTAB that we have issues with, right? So just to make that very clear. Now, we're going to have lunch in just a second, but anytime you should actually go and visit these different booths. On the far left here is the Black Inventors Hall of Fame. That's James Howard's group. Right next to it is SRIP Law. That's Joel Rothman. Right next to it is Navigation IP. That's Jeff Harden and Patricia Duran. Navigation IP, Jeff is starting to do consulting. You could ask him about a win he just had against a couple of big tech companies. I think he can talk about it. Maybe I shouldn't have said that. I don't know. Anyway, then you have Modern IP Group. That's Steve Taylor. He's working with inventors, looking for guys that they can raise money and go after some infringers. There's Joy's Medical Concepts over here. Joy definitely wants to talk to you about what she invented. There's Aurora Patents over here. That's Josh and Ashley Sloat. They'll film you. They'll put you on their podcast. If you got a story, definitely get with them. And I believe that's it. Thank you, everybody, for being here. Let's have lunch, and at 1 o'clock, we'll be back for the next panel. Thank you.